Today, we are diving into a legal battle that all started with something super simple, a request to build a wall, and somehow ended up in a courtroom. Honestly, it's a huge cautionary tale for any homeowner out there with a big dream and an HOA with, well, a big book of rules. It's the kind of question that probably keeps some homeowners up at night, right? You've bought the house, you've got this amazing vision, but a committee of your neighbors, they get the final say. So how much power do they really have? Let's get into it. Okay, so let's meet the folks at the center of this whole thing, Arthur and Viktoriya Fisenko. All they wanted to do was build a pretty standard block wall on their property. But their HOA, the Bellvue Homeowners Association, said no. And that single word kicked off a massive legal fight. To really get what's going on here, we first have to understand the rule book that everyone in this neighborhood has to play by. Because it all comes down to a contract that every single person signs when they move in. So on one side, you've got the Fisenkos, the homeowners. And on the other side, you have the Bellvue Homeowners Association, specifically its Architectural Review Committee. You can just call them the ARC. They're basically the gatekeepers for what the neighborhood looks like. The whole argument really hangs on this one thing, the CC&Rs. You should think of it as the neighborhood's constitution. When you buy a house in a community with an HOA, you are legally agreeing to follow this rulebook. It's what gives the HOA the power to approve or deny projects, all in the name of keeping up community standards. All right, let's trace the timeline here, because you are going to be shocked at how fast this went from a simple request to an all-out legal war. Just look at how fast this thing blew up. The Fisenkos send in their plan on February 8th. By April 1st, instead of just giving the HOA the details they asked for, they've already hired a lawyer. And less than 3 weeks after that, they're suing their own HOA. We're talking from renovation plan to lawsuit in less than 80 days. Wow. So why'd they get denied in the first place? Well, according to the court documents, the HOA's concerns were pretty practical. The application was basically just a photo with some notes scribbled on it. It wasn't clear how long the wall was going to be, and the committee was worried about how it might affect the next-door neighbor's property. And this right here, this was the turning point. The HOA didn't just slam the door. They said, hey, just send us a complete application, with a real plot plan, elevation details, the kind of stuff that's totally standard for any construction project. But instead of doing that, the Fisenkos decided to lawyer up. And that, of course, brings us straight to the courtroom, where lawyers for both sides got to lay out their case in front of a judge. So in court, you basically heard two completely different stories. The Fisenkos claimed their mistakes on the application were just excusable errors, just regular homeowners trying their best. The HOA's argument was way simpler. The application was incomplete, and this whole legal mess was completely unnecessary. So you've got these two totally conflicting stories. How does a judge even decide who's right? Well, the answer comes down to a really important legal idea. And this is the absolute key to the whole case. The burden of proof was on the Fisenkos. It was their job to prove that the HOA acted unreasonably. It wasn't up to the HOA to prove they were right. It was up to the homeowners to prove the HOA was wrong. So were they able to prove it? Nope, not even close. The judge's decision was crystal clear. Petition denied. The Fisenkos lost their case. But why they lost is the real lesson here. This quote from the judge's final order really says it all. The judge basically concluded that the HOA couldn't have been unreasonable because the Fisenkos never gave them the information they needed to make a reasonable decision in the first place. That incomplete application was the fatal flaw. So what can we all learn from this expensive, time-consuming mess? I mean, for anyone living in an HOA, this case is pretty much a masterclass in what not to do. Okay, this is basically your roadmap to not ending up in the same boat. First, just know the rules. Read your CC&Rs before you even start planning. Second, be thorough. A complete application isn't just a hassle. It makes sure everyone is on the same page. Third, and this is where the Fisenkos really went wrong, cooperate. If the board asks for more info, see it as a conversation, not a fight. And finally, and this is the big one, talk it out before you lawyer up. A simple conversation could solve a misunderstanding, but a lawsuit? Well, a lawsuit just turns your neighbors into your enemies. At the end of the day, this whole case leaves us with a really interesting question to think about. Is your HOA a helpful guardian protecting your biggest investment? Or is it just an obstacle getting in the way of your rights?
As the Fisenkos found out the hard way, the answer often depends on whether you understand and are willing to play by the rules of the game.